Hi everyone, good morning, good afternoon, or good evening to all of you. My name is Nika Alame El Villanes, and in this video, we are going to present to you the legal environment of human resource management. Okay, so in this video, we are going to tackle about laws and regulations, about businesses, or about HRMO, or HRM, Human Resource Management Office. It plays an important role, especially for the employees and staff of an institution or businesses. Now, before we start, allow me to present to you the objectives of this report or this presentation. We have 6 objectives here, which is number 1 is to understand the role of law in business and society, familiarize with new key areas of law affecting businesses, recognize the structure of the legal system, apply legal concepts to the real-world situations, promote ethical and lawful decision-making, and lastly is to evaluate the impact of laws on business strategy and operations. So that's the objectives for this video. Now, let's move on to the table of contents. We are going to tackle about the unequal payment for equal work, the legal concept of human resource management, equal employment opportunity, other areas of human resource regulation, contemporary challenges in HR, and evaluating legal compliance and power plays at work. So that is the objectives and also the table of contents of this research or presentation. Now, I want you to think of any ideas that comes in your mind when you see this kind of words. So there's 4. Unequal payment for equal work, discrimination, unfair treatments, or laws and regulations. So what comes in your mind when you saw something like words or phrases like this? So I know a lot of you have lots of ideas of what these words or phrases means, but allow me to explain you further what does it mean, or what is the relationship of this kind of words to the HRM or to the employees or society in our city, or not just in our city but in our country. So let's proceed. Let's start with unequal payment for equal work. According to the research, women earned around 78% of what men earn for performing similar jobs. So this kind of situation like this usually happens in American countries, according to Abraham in 2015. But then something similar situations like this also happens in the Philippines, but only few of them. Okay, so why does it happen? What is the factors, or ano ang mga rason kung bakit ito nangyayari? So there is number 1, discrimination. Number 2, negotiation gaps. And number 3 is lack of knowledge about the ratings or salary rates. Okay? So, for example, Aura and Akol is both a marketing specialist in a company. So, they have the same credentials, they have the same works, they have the same degree, they have the same, lahat ng pinag-aaralan nila at lahat ng work nila is same. But their salary is different. There is a big difference in their salary. So what is the possible reason for that? So number 1 is that Akol is better in negotiation, which is during hiring, he negotiates that his salary must be at this rate, or he demands that his salary must be at this rate, while Aura, on the other hand, demands nothing. Okay? She doesn't perform negotiation, or she doesn't negotiate with the salary rates, while Akol demand for a 1. Okay, so that's the one reason. Number 2 reason is that there are companies that considers men as the provider, the man of the house, or the financer of the house. So they are considering that to all men, thus they are giving men a high salary to finance their families. Okay, so there is 2 issues, which is the discrimination and negotiation gaps. So let's proceed to the second one, which is the Title VII of the Civil Rights Act of 1964, which states that the Title VII is the primary federal law that prohibits employment discrimination based on race, religion, color, and sex or gender. Okay, so this law, or the Title VII of the Civil Rights Act of 1964, is the basis that there should not be a discrimination regarding race, color, religion, sex, or gender in an establishment, in an HR, or in a business. Okay, that is the act for the employees, and of course, a basis for the employers. Okay, that there must be no discrimination. Okay, it is strictly prohibited to have or to perform discrimination in HR or employers or employees or applicants. Okay, so there must be no discrimination among the protected groups. So next one, Equal Pay Act of 1963. It states that specifically stipulates that organizations must pay the same wages to the men and women who are doing equal work. So this act is for the employees to have a equal treatments or equal salary rates to those who are also equal in works. Okay, for example, Akol and Aura. Akol and Aura is both a marketing specialist, so they have the same work, they have the same field, so they must be same or there should be dapat same din sila ng salary rates. Okay, so there is equal pay in equal work. Okay, so if that's again clear, let's move forward. Let's proceed, which is we are in the mommy truck phenomenon. Mommy truck phenomenon wherein states that a woman needs to stop working in order to have a baby. Okay, so this phenomenon or this theory sometimes discriminates women at work. For example, Aura is a 9 months pregnant or kabuwanan niya na. Okay, so she needs to stop working para magpahinga at ready na mag-labor. Okay, so she needs to stop working. Nung nanganak na siya at lahat-lahat, kailangan niya pa rin alagaan yung bata, of course. So she stopped for 3 years, and after 3 years, she returned. Okay, so in her return, balik siya sa umpisa. Okay, balik siya sa umpisa. Kasi sa maternity leave, there are only 105 days according to the research. There are only 105 days paid maternity leave. Okay, yun lang yung maximum days ng maternity leave. So sa kanyang pagbalik, after her 3 years of absence, balik siya sa una. So yung mga nakasabayan niya, which is marami ng opportunities na na-acquire or nakuha, such as salary rates, or parang nataas yung salaries nila, more promotions and everything na tumaas, or parang opportunities for them. So parang si Aura, parang nadismaya siya sa sarili niya because why she needs to stop, ganto ganyan. So parang magkaroon siya ng doubt sa sarili niya, why ang mga kasamahan ko is in that position na or in that salary rates na, and then ako back to basic pay. So that discriminates a woman. Okay, so maternity leave should not only for 105 days according to the research, according to the counterpart research of this act. Okay, because a mom should be at least 1 year in a mom duties, or at least 6 months of a mom duties before entering to the job. So next one is the legal context of human resource management, which is shaped by different forces. Okay, so legal context of human resource management, dito na sila yung gumagawa ng mga laws and regulations. Okay, dito nabubuo yung laws and regulations. So they are shaped, or legal context of human resource management shaped by different forces. Number one is legislative initiative, which is a government initiative. Okay, a government initiative. It is made by the government initiative. So example of this is the sick leave, maternity leave, emergency leave, vacation leave, na kung saan is paid. Okay, it is one of the benefits of being an employee. Okay, so next is the social change. So there's instances that a law needs to adjust for a social change. Okay, so for example, right now we are prioritizing, or malaking bagay sa atin ang discrimination, equal rights, or equality, gender equality, and so much, and mental health, ganon. So a law should adhere to that social change. So they need to have a laws and regulations regarding that matter, because it is the new changes or the new society. So they need to adhere and comply to that. Okay, so next one, or the last one, is the judicial rulings, which is a order from the court, which is if ever a human resource management office ay nagkamali sa pag-fire ng employees at napatunayan ito sa court, maaaring kasuhan ang HRMO kasi mali ang kanilang process ng firing of employee. Okay, so that's the legal context of human resource management. Next, we have here the regulatory environment of human resource management. So there are three-step process para mabuo ang isang rules and regulations. Okay, so number one is the actual creation of new regulations. So this is the brainstorming, this is the parang meeting ng board members, ng senators, and etc. and all, para gumawa ng, or para iangkop ang gagawing legal laws or legal systems sa Pilipinas, sa state ng Pilipinas. Okay? So next one is the enforcement of regulation. So in this process or in this level, they are parang ini-evaluate nila if effective ba or if nakakagawa ba ng magandang dulot itong rules or regulation na ito. And then lastly is the actual practice of implementation. If ever na they think that it is, or napatunayan na nila na it is very effective, then doon na sila mag-command na this should be practiced and implemented. Okay? That's the step-by-step process of the regulatory environment of human resource management. Okay? So again, lahat ng mga rules and regulations ay usually hindi nanggagaling sa HRMO. It came from the legislative initiative, yung tatlo, the legislative initiative, social change, and judicial rulings. Okay? Hindi yan buot-buot ng HR lamang, kundi meron silang basis sa rules kasi they cannot provide or they cannot issue rules and regulations without a basis because that's illegal. Okay? So next one is the equal employment opportunity. So in this case, the local government unit or the lawmakers made an equal employment opportunity for both prospective employees and also current employees. So for prospective employees, they have a benefits or they have opportunity to being protected from the discrimination in selection, initial job placement, and initial compensation. For the current employees naman, they have opportunity to protection from discrimination in performance appraisal, subsequent role placements, and so much and more. Okay? So if you are still a prospective employee or a current employee, merong opportunity sa inyo or merong benefits sa inyo or rules na para sa inyo na ginawa ang lawmakers or ang HRMO. Okay? So, what is the benefits of equal employment opportunity? It is to test or it is to give an equal treatments to the prospective employees and the current employees that they both have the same opportunity even though they are prospective lang or they are current employees na. Okay? So, let's proceed to the discrimination and equal employment opportunity. So, in this case, we are going to tackle about different types of discrimination in HRMO or in offices or businesses and also equal employment opportunities ng mga employees. Okay? So, the first one is the illegal discrimination. Behaviors or actions by an organization or managers within an organization that cause members of a protected class to be unfairly differentiated from others. So, for example, itong illegal discrimination na ito, parang merong rule ang isang HR na kung saan they think it's fair enough. But they don't think or wala silang malay na nakakapag-discriminate na pala sila ng protected groups. Again, ang protected groups is yung may mga special characteristics or may mga characteristics na hindi nino-normalize ng mga tao such as a race, color, gender identity, and so on and so forth. Okay? So example of this illegal discrimination is that when you are applying for a work or for example, let's make NDU community as example or NDU HR as an example. So example, ang HR ay may height requirement sa pagpipili ng job. Sa pagpipili ng employees. So, their height requirement is about 5'1 or 5'2. At least you are 5'1 or 5'2. Okay? So, they think that it's fair because a lot of Filipinos or Filipino citizens are in that kind of height. Okay? For example, lang ito hindi siya realistic, but it can be also happening. Okay? So, yun na nga, meron silang height requirement na 5'2 because they believe that all Filipinos, women, is around that height lang, 5'1 or 5'2. But then, they don't know that there are specific protected groups that has different race, color, or etc. that is not around 5'1 or 5'2. So, they feel differentiated. Okay? So, yun, they feel differentiated because of the height requirement. So, in their culture, the average height for them is the 4'11 or 5 flat. So they are not into the requirement. So they are not going to be employed. Okay? So that's one of the illegal discrimination. There should be an equal treatment to individual groups or to the protected groups. Okay? The bona fide occupational qualifications. So this means that some personal characteristics such as age legitimately affects a person's ability to perform the job. So, in this case, this bona fide occupational qualification is not a discrimination, but a favor or a favor to a employee na merong kakaibang characteristics. Okay? For example, I have different, or parang meron akong sakit sa paa, or meron akong injury sa paa, ganun, na ongoing yung treatments. So, nag-apply ako sa HR, and then, ang dapat lang na i-assign sa akin is yung nakaupo lang ako. Okay? Yung mga wala masyadong lakad-lakad ng work. Because, how can I work na merong paglalakad na involved kung baldado naman ako? Diba? So, that's what you call bona fide occupational qualification. It is a favor na binibigay sa'yo na dapat dito ka lang mag-work kasi ito lang yung mababagay sa'yo, at dito ka mas dapat na nakalagay kasi dito ang specification. I mean, dito ang dapat na kinalalagyan mo. Not to discriminate, but to give them a favor. Okay? Paano mo put into words yan? Diyan ka nilagay kasi doon ka dapat nilagay. Kasi you are bald. I mean, baldado ka. So, doon ka dapat nilagay because doon ang less work. Okay? Less work na hindi mo na kailangan maglakad-lakad. Okay? So, that's one of the example of bona fide occupational qualification. Again, it is not discrimination, but it is a favor given to a employee. So, let's proceed to the different type of disparate, which is the disparate disparate treatment and disparate impact. So, for the disparate treatment, it means it is an intentional discrimination among protected groups. Okay? So, this is an intentional discrimination. Ang disparate impact naman is unintentional. That they think it's fair, but it's not. Because it's hurting the protected groups. Okay? So, for example, sa isang kumpanya, or sa isang department na kayo, hindi ka pinapansin because you are black. Okay? You are black. So, parang ignorante yung mga Pilipino kasi you are black. Feeling nila, feeling nila kakaiba ka. Or pinapa-feel talaga nila na kakaiba ka. So, hindi ka pinapansin masyado because you are black. So, that's a discrimination. While lahat sila, nagpapansinan, or lahat sila is may magandang samahan, kumakain sa labas, and etc. But you are not invited, or you are treated differently among others na kapwa nila Pilipino. So, that's one of the example of disparate treatment. It is intentional. Okay? Intentional. Now, let's move on to disparate impact, which is they perform like behaviors na unintentional but it hurts the protected group. For example, is yung hiring ng mga employees na merong specifications. Okay? So, di ba sa act is dapat meron tayong equal treatment, right? Sa pag-hire ng employees. But, kunyari, sa isang HR, but not sa HR ng NDU ha, sa ibang HR, meron silang specifications when it comes to hiring. Okay? Na they think it's fair, but it is unfair for the protected groups because they are being treated differently. Okay? So example of disparate impact is that if example, I am a gay, okay? Sorry for if I am using this example, but for example lang naman, I am a gay and I am applying for a labor work, okay? I am applying for a labor work. So they won't employ me or hindi nila ako tatanggapin because I am a gay. Kumbaga, they discriminate me because ang nasa requirements nila is lalaki lang. I am a boy, but a gay. Okay? I am a boy and I can do that also. No? So, there are unintentional discrimination. Kumbaga, sumusunod lang din sila sa requirements, but there is a discrimination among protected groups because they felt different, though they are boy, but they felt different because they are gay. Okay? So, that's one of the example of disparate impact. So, next is the 4/5 rule, which is a branch of disparate impact. So, it means it exists if a selection rate of a protected group is less than 80% of the rate for the majority group. So, for example, ang majority group na lang is a male, okay? Ang majority group is male. And then, ang protected group, which is yung may mga special characteristics such as special race, color, gender identity, religion, and others. So, less than 80% sila. Okay? Yung male, which is yung majority group, is more than 50%. Tapos, yung female is 40% lang. Okay? So, there is a discrimination. So, itong 4/5 rule kasi, ang rule dito is that kung 50% man yung pag-employ nila sa male, dapat pasok or dapat ang employee nila na female is 80% ng 50%. Gets? So, kung ano ang 80% ng 50%, dapat yun ang number ng female or protected groups na kanilang in-employ. Okay? So, that is the 4/5 rule. Dapat, kung 50% yung in-employ nila ng male or majority group, dapat 80% nun is yung number ng in-employ nila na protected groups or yung female. Okay? If that makes sense, I hope. So next is the geographical comparison. So this involves comparing the race, ethnicity, and gender of qualified job applicants to those of current employees in the same role. Okay, so for example of this is that you are applying for a job. Okay, so kunyari ako yung employer. So merong nag-apply for a job. So, bago ko siya tanggapin, kailangan ko munang tingnan yung kanyang resume. So, kung anong group ba siya ng people na belong, ganito ganyan. So, I need to parang scan yung kanyang gender, race, ethnicity, ganito ganyan, para i-compare ko doon sa current employees. So, kung yung current employees ko ay mga Christians and then mga Tagalog, so I need to hire someone na Christians din and Tagalog. So, there is a geographic comparison and also a discrimination. Okay? So, yun yung tinatawag na geographic comparison. Kino-compare mo yung pinanggalingan ng applicant sa current employees mo at kung ano yung pinanggalingan ng current employees mo, yun ang i-approve mo or i-employ mo. Okay? Next is pattern or practice discrimination. This is when a company discriminates against a whole group of people, not just one person. So, for example, ang isang HR office is hindi tumatanggap ng mga Tedoray people. Okay? So, kahit sino pa yan, kahit gaano pa kataas ang inyong rating sa board exams, kahit gaano ka pa katalino, kapag Tedoray ka, is hindi ka tatanggapin. Again, this is just an example, okay? No bad feelings or no hurt feelings about the examples. Okay? So, yun ang pattern or practice of discrimination. Kumbaga, pre-practice na nila or parang pattern na nila na hindi magtanggap ng mga Tedoray people sa work, even though kung kahit gaano pa yan kataas ang credentials mo. Yun na talaga ang nakasanayan nila. Okay? So, yun. So, lastly, for my part, there is retaliation and employer defense. So, retaliation means punishing an employee for exercising their legal rights, and employer defense is legal reasons an employer gives to justify their actions. So, retaliations, for example, or retaliation, ito yung mga if ever na nagreklamo ka, employee sa inyong employer, tapos finire ka kasi nagreklamo ka and you were sued for para na nagreklamo ka. Gets ba? Okay. So, for example, nireklamo ko ang boss ko kasi nagdi-discriminate siya sa mga workers. So, pagkareklamo ko sa kanya, napunta sa HR and then a process, but then, since boss ko nga siya, I was being fired. Okay? So, na-fire ako or natanggal ako sa trabaho and then, nagkaso pa ang boss ko. So, that's what you call retaliation. Okay? Pinapunish nila ako or nagdedemand sila or parang nagbibigay sila ng punishment sa akin dahil nagreklamo ako regarding or sa aking boss. Okay? So, that's the retaliation. So, number 2 is the employer defense or the last one. Employer defense is a legal reasons an employer gives to justify their action. So, of course, if may rights ang employees, meron din namang rights ang employer. So, if ever na the employee accused you for something or the employee accused the employer for something, they have the rights to submit legal documents or legal evidences para ma-prove na they are wrong or the employee is wrong for accusing them. Okay? So, yun yung employer defense. They can defend or they have the legal rights or actions na pwedeng gawin para ma-prove na tama sila. Okay? So, that's it, guys.
Sa madaling salita, ang protected class in the workplace ay mga grupo ng tao na may pare-parehong katangian na pinoprotektahan ng batas laban sa diskriminasyon sa trabaho. Affirmative action ay mga hakbang na ginagawa ng isang organisasyon para tulungan ang mga taong underrepresented o madalas na discriminate sa trabaho, kagaya ng mga babae o may kapansanan, na magkaroon ng pantay na oportunidad sa employment. Tatlong mahalagang elemento ang affirmative action. Una, yung utilization analysis. Ito yung mga paghahambing ng kasalukuyang workforce ng kumpanya kumpara sa available labor supply sa paligid. Halimbawa, kung 10% lang ng empleyado ng isang engineering firm ay babae, pero sa local labor market ay 40% ng engineers ay babae. Ibig sabihin, underutilized ang kababaihan sa kumpanya. Kailangan gumawa ng hakbang para dagdagan ito. Pangalawa is yung development of goals and timetables. Dito, nagsiset ng target or goal at oras kung kailan maaabot ang nais na bilang ng protected group sa workforce. Halimbawa, ang isang kumpanya ay maglalagay ng layunin na by 2030, 30% ang bagong hires nila ay magmumula sa minority group para maging mas diverse ang workforce or workplace. Pangatlo is yung development of action steps. Ito yung mga plan o mga steps na gagawin para maabot yung mga goals. Maaaring kabilang dito yung mag-post ng mga job openings sa mga lugar na maraming minority applicants o di kaya pagbawas ng mga hadlang sa employment tulad ng unfair hiring test. First discrimination happened late 1990s where court began impose many more restrictions on what was acceptable or required in the way of preferential hiring. So, ito yung mga paniniwala na nabibilang sa sobra o di pantay na pabor ang mga protected groups. Kaya naman parang nadi-discriminate ang mga hindi kabilang sa kanila at tinatawag silang non-protected class. Sa EEOC or Equal Employment Opportunity Commission, ang sexual harassment ay tumutukoy sa mga hindi kanais-nais na sexual advances o kilos na may halong sexual na intensyon sa loob ng workplace. At ito ay labag sa batas kapag nangyari sa professional environment. Pagdating sa korte, may dalawang types ang sexual harassment. Una, yung quid pro quo harassment, which is the harasser offer to exchange something value for sexual favors. Ito ay nangyayari kapag ang isang tao sa posisyon ng kapangyarihan ay nag-aalok ng kapalit tulad ng promotion. Kapalit ang sexual favors. So, ang hostile work environment naman is the one that produces sexual harassment because of a climate or culture that is punitive towards people of a different gender. Halimbawa nito is yung laging nagbibigay ng mga green jokes, poster ng mga malaswa, pambabasto sa mga babaeng empleyado, at paulit-ulit na pagkomento sa katawan o itsura ng isang tao. Ito yung nagbibigay or nagdudulot sa mga tao ng takot, hiya at discomfort.
Pregnancy Discrimination in the Workplace. PDA or Pregnancy Discrimination Act of 1978 protects pregnant workers from discrimination. So, the Pregnancy Discrimination Act of 1978 protects women from discrimination based on pregnancy, childbirth, or related medical conditions. Employers must treat pregnant employees the same as others with similar ability or inability to work. This ensures job security, benefits, and equal treatment during job pregnancy. So, why do pregnancy-related discriminations happen in the workplace? So, nangyayari ang pregnancy-related discrimination in the workplace kasi before this law, many women were fired, demoted, or denied jobs just because they were pregnant. So, nagiging unfair yung nagkakaroon ng hindi fair na situation kapag may pregnant na lady because hindi sila natitreat ng equal kasi sila ay pregnant. So, to protect pregnant workers from being treated unfairly and to guarantee their right to work while pregnant, Pregnancy Discrimination Act of 1979 was made. So, these are the supporting laws of PDA. ADA, which accommodates for health conditions, EPA, equal pay regardless of gender, and ACA, support for nursing mothers. Next is age discrimination in the workplace. So, age discrimination in the workplace reduces job satisfaction and motivation, increased stress and mental issues, limited career growth, and income opportunities for older workers. So, Age Discrimination in Employment Act or ADEA of 1967 protects workers aged 40 and above from discrimination in hiring, promotion, pay, and termination. This promotes equal opportunity for older workers and challenges stereotypes about aging and productivity. So, na-invent ang Age Discrimination in Employment Act kasi because older workers were often rejected for jobs, forced into early retirement, or passed over for promotions. So, na-invent ito to prevent employers from discriminating based on age and ensure equal opportunities for workers over 40.
Civil Rights Act of 1991 strengthens protection against workplace discrimination and allows victims to sue for damages. The Civil Rights Act of 1991 is a law that gives stronger protection to employees against discrimination at work. It makes it easier for people who experience unfair treatment based on their race or gender, religion, or other factors to take legal actions. This law also allows victims to ask for money as compensation if they were harmed by the discrimination. Americans with Disabilities Act or ADA protects people with disabilities from job bias and requires employers to provide reasonable support. The Americans with Disabilities Act or ADA is a law that helps protect people with disabilities from being treated unfairly at work. It makes sure that employers do not discriminate against them when hiring or in the workplace. The law also requires employers to provide reasonable help or changes like ramps or flexible schedules so people with disabilities can do their jobs. Family and Medical Leave Act or FMLA grants up to 12 weeks of unpaid leave for health, family, or military reasons with job protection. The Family and Medical Leave Act or FMLA is a law that allows employees to take up to 12 weeks of unpaid leave for important personal reasons like taking care of a new baby, a sick family member, or their own health problems. It also covers certain military-related needs. While the leave is unpaid, the law ensures that the employee's job is protected and they can return to the same or a similar position afterwards.
Let's now proceed to the next topic, which is the regulations for federal contractors. So federal contractors is basically, it can be an institution or a company that does business with the government. Kung mayroong contract between a company and the federal government in the US, then that company or institution is considered a federal contractor. So yung mga employees doon is considered as a federal contractor. So under a federal company, there are rules and regulations and laws that federal contractors are bound to follow. So one of them is actually two of them are the anti-discrimination law and the equal opportunity rules. So the first executive order from President Johnson is the Executive Order 11246. So this executive order basically rules that companies are not allowed to discriminate employees based on their skin color, based on their religion, sexual orientation, or even physical appearance. So, yung mga companies or institutions that receives more than $50,000 contract from the government are mandated to create a plan to hire more women and minorities. Second executive order is the Executive Order 11478 from President Nixon. So this executive order applies to all federal companies that receives more than $10,000 in contract. So itong executive order naman ito is it requires that all governments are bound to base their decisions on hiring people based on skills and abilities only. So they're not allowed to base their decisions sa skin color, sa religion, sexual orientation. Kailangan sa skills and ability lang sila. As long as that person is capable on doing their job, then walang reason kung bakit hindi sila pwede i-hire. So, moving forward, sa Vocational Rehabilitation Act of 1973, so yung mga federal contractors that receives $2,500 or more contract from the government are also mandated to hire people with disabilities within their company. So, a very recent rule that was added way back in 2014, the Section 503, it asks companies to have at least 7% of their employees to be person with disabilities. So for the next topic, which is the discrimination based on sexual orientation, there is a law, which is the DOMA Law, Defense of Marriage Act, which protects same-sex couples from not having equal access to pensions and insurance. So this law was passed by then President Bill Clinton way back in 1996. In 2015, court legalized same-sex marriage nationwide. So a year after, or a few years after, same-sex marriage was legalized, and at the time President Obama was the president. So unlike the DOMA, it was limited. The DOMA was limited from other cities in the United States, but then in 2015 the same-sex marriage legalization was nationwide. So yung impact on HR and society is that mas equal na yung access ng mga same-sex couples sa pension, insurance, because HR departments adjusted their benefits policies because of the legalization of same-sex marriage. Enforcing equal employment opportunity. So under this are two main agencies, which is the EEOC, or Equal Employment Opportunity Commission, and OFCCP, which oversees federal contractors, which was mentioned on the first topic, the regulations for federal contractors. So yung EEOC naman is, it has three main functions on a federal institution. The first one is they investigate discrimination complaints, they collect workforce data, and they issue guidelines for legal hiring and promotion practices. So yung investigating discrimination complaints is that when an employee is being discriminated or may complain galing sa employee about being discriminated, they are the ones to investigate the situation. So pag naging successful yung pag-investigate, there will be punishments from the people involved on the discrimination. But then if the investigation was a failure, then an employee who was discriminated or who filed the complaint can file a lawsuit at a federal court. So sa collecting workforce data naman is that they are the ones who are collecting the data when it comes to hiring people. So hiring people and also the employees in an institution. So sila yung nagbabantay if pantay ba yung amount ng lalaki at babae na employee within the company. So lastly is the issuing guidelines for legal hiring and promotion practices. So they set rules and guidelines for the companies kung paano sila mag-hire, which is the main point is to not have discrimination when it comes to hiring and promoting employees. So other human resource laws beyond EEO. So this includes wages and benefits, workplace safety, labor relations, and employee privacy. So there are compensations and benefits laws. So the first one is FLSA, ERISA, and ACA. So the FLSA is Fair Labor Standards Act, which was passed in 1938. So it was established the first minimum wage and set the 40-hour work week. So these are the different wages. So the first wage was $0.25 per hour, but then today it became $7.25 per hour since 2009. So Mr. President Obama wanted to push it to $10.10, but then it wasn't passed. Federal contractors saw a raise to $10.15 way back in 2015. So state and city wages examples. So many states set higher wages than the federal level. So in California, their wages is $10 per hour. In Los Angeles, $15 per hour by 2020. In Massachusetts, $10 per hour. Washington, D.C., $10.50. In Oregon, which is very recent, based on the new reference, is $14.75 in Portland, $13.50 in urban, and $12.50 in rural. So under FLSA is also the exempt versus non-exempt. So exempt employees, usually salaried, do not get overtime. So in Perez mortgage bankers way back in 2015, the Supreme Court said that mortgage bankers are non-exempt, meaning they do qualify for an overtime. So FLSA also protects child labor rules, which protects workers under 18, restricts dangerous jobs, and limits working hours for those under 16. Next is the ERISA, which is the pension protection, passed way back in 1974, which protects employees' pension rights. It ensures workers get the retirement benefits they've earned, prevents employers from misusing pension funds, but it doesn't require a company to offer a pension. It is just a protection, promised benefits.
So hello everyone, I'm going to discuss the contemporary challenges in HR or human resources. So first is, what does the FSLA require regarding overtime pay, and does it limit the number of hours employee can work in a single day? So ayon sa FSLA or Fair Labor Standard Act, na ang mga full-time na mga employees ay dapat bayaran sila na 1.5 times their normal hourly rate for each hour of work beyond 40 hours per week. And thus the normal work day might be considered as 8 hours. So ang mga employees is pwede sila mag-schedule ng 10 to 12 hours without paying overtime as long as they exceed the 40 hours in a week. But the law of ERISA or Employee Retirement Income Security Act of 1974, this law ensure that at the time of retirement or turnover, ang mga employees ay makuha silang some of pension benefits. So next is, what was the primary purpose of the National Labor Relations Act or Wagner Act of 1935? So the Wagner Act aimed to control legislative collective bargaining between organizations and labor unions, creating a more balanced power relationship after a period where the legal system was considered hostile to labor unions. It also outlined the process for forming labor unions and the requirements for organizations dealing with them. To make it short, the primary purpose of the National Labor Relations Act or Wagner Act of 1935 was to control and support fair collective bargaining between organizations and the labor unions. So at this point, the Occupational Safety and Health Act of 1970 or OSHA is the most comprehensive legislation regarding worker safety and health, granting the federal government the power to establish and enforce standards for all places of employment affecting interstate commerce. So the OSHA or the Occupational Safety and Health Act law gives the government the power to make and enforce rules to keep all workers safe. So at this point, the Occupational Safety and Health Act of 1970 or OSHA is the most comprehensive legislation regarding worker safety and health, granting the federal government the power to establish and enforce standards for all places of employment affecting interstate commerce. So the OSHA or the Occupational Safety and Health Act law gives the government the power to make and enforce rules to keep all workers safe.
Now we will talk about the plant closing and employer rights. So first, what is WARN or Worker Adjustment and Restraining Notification Act of 1988? So this is about an organization that has at least 100 employees pataas na they must give an at least 60 days in advance prior notice if they will be having a layoffs or di kaya closing down of plants. If hindi nila nasunod yung 60 days na yun is magkakaroon ng penalty. So the penalty will be they must pay the employees and also they must provide a benefit. So for example, an organization is closing down tapos hindi nila nabigyan ng at least 60 days in advance prior notice, so they must pay those 100 employees ng $500. So and also they must give a benefit, like sabihin natin is life insurance, mga ganon. Bali, it will be costly pero fault rin talaga ng organization na hindi sila nag-provide ng at least 60 days. And also, this law is to help the employees give time to find a new job, and also prepare for financial loss. Ganun. So, meron din exemption is about sa unforeseeable business circumstances such as strike at a major employer. So, ibig sabihin is ang workers na stop mag-work to protest dun sa company yun sa labas for better conditions, like sabihin natin increase of pay kasi mababa yung bayad sa kanila. And also for the government, like for health safety. Example is COVID-19. So our next topic is about the privacy issues at work. So sa ngayon, hindi na rin nakakapagtaka na important na rin yung privacy sa US, especially sa work nila. So included dito yung monitoring of employees, personal data, emails, and health info. So meron ditong law, which is the Privacy Act of 1974. So this Privacy Act of 1974 is applied only for federal employees of the US. So for US federal employees lang talaga ito, hindi siya applied dito sa atin since meron din tayong sariling law about this. So this is about they can review their personal info every month to make sure walang counterfeit or di kaya pagbabago, since before nung law na to is may issue talaga or totoo man na yung mga managers is pinapalitan doon nila yung information ng mga employees nila, then wala rin karapatan ng mga employees na mag-check ng information nila if may napalitan ba or hindi. So, ganun. Then, hindi rin nila pwede palitan kung ano yung pinalit ng manager nila dun sa information na yan. So, ganun. Late 2009, Congress passed a law about different types of privacy. So, first is GINA or Genetic Information Non-Discrimination Act. So, this law is about to protect the employees from sharing their family genetics to avoid discrimination or bullying. So, hindi included dito yung health records nila. So, the next one is the Patriot Act. So, correction lang dun sa date na September 11, 2001. It is supposed to be October 26, 2001 since yung September 11, 2001 is start ng attack ng mga terrorist sa US. So, bale, itong law na to is to help the US fight the terrorists effectively. Bale, there are some major provisions included. So, first is the surveillance. So, they're authorized na makalisten sa mga phone calls o di kaya maka-review ng emails ng ibang tao or di kaya maka-access sa CCTV. So, next is secret investigation. So, the government can investigate without telling other people, like parang detective ba, na syempre investigate ka para mahuli mo yung mga tao na mayroon sketchy things na ginagawa. You know? So, next is search warrant at any cases. So, they can carry search warrants kahit saan. So, like, kunwari mayroon lugar na may terrorist activities or sketchy. So, pwede na pasukin yun with the use of search warrants.
This closing case is entitled Powers Placed at Work. A study in the US shows that 30% of the female employees there experience sexual harassment, mostly done by men. And in those men, 43% is galing sa mga supervisors nila, 27% sa mga senior employee, and the 19% is mga co-workers nila or employees with the same position. It was also found out that 13,000 sexual harassment cases were filed with the EEOC last 2012. And doon sa 13,000 na yon, 84% is galing sa mga babae. Question: why does sexual harassment most nangyayari sa mga babae happens inside the workplace? One researcher, David Doherty, states that power is the root cause or reason why nangyayari ang harassment, mostly sexual harassment sa workplace. It is also because na merong different perspective or perception ang babae at saka lalaki sa term or word na power. Ano nga ba ang perception ng babae at saka lalaki sa term na power? For men, power is somewhat related to superiority. Like, the more or the higher the position that you have, the more power or privilege that you gain. As for the women naman, power is how you carry yourself in front or towards the others.
if you can show us intimidating to them, you have the strength, or you have the intelligence to lead them. According to David Doherty, this difference in perception of power what drives the other to harass or be harassed. Like, if the man thinks that he is in the position to harass, then he will do so. University of Minnesota supports the idea of Doherty. In their study, they have found out that 137% of women in supervisory positions are more likely to be harassed than those in the regular positions. Their research clearly shows that na the more umaangat yung babae, the more na magiging unfair yung treatment sa kanila. Base or possible reasons siguro dito is yung intimidation tactics and the workplace backlash. Power perception. It is when someone with the authority believes that he has the right to control or intimidate others, then this is most likely will lead to harassment. Then, if the company will be able to find out about the situation and proves that the situation really did take place, then the harasser will most likely face civil or criminal charges depending on the acts that they did. This case stresses the importance of legal frameworks within the company or the workplace. This legal frameworks is the one that holds the company and its employees together. Without it, there will be an imbalance in the company's workforce.